Kajing Bishar bahek do apok kajela ke Meghalaya High Court haringkat kajingas nok tilang bat ke Meghalaya State Judicial Academy hakasan tarik urisau arja arpulai kala penlongai ke lempung halor kamat kajing penklanya kajing toket bat kajing kem dagi Pulit lani strengthening police investigation and prosecution haka auditorium Jongka High Court. Yakani ka workshop lalam khamad o Chief Justice ka Meghalaya High Court u Justice Sanjeev Banerjee haringkat ka jingadon lang u Justice Hamar San Singh Thangkhiu u Justice Wanlura Dingdo bat u Justice Biswadi Bhattacharjee. Hakani ka workshop ka bala penlong halor ka jing penklanya ka jing toket ba ka jing kem dagi Pulit u Justice Sanjeev Banerjee u Chief Justice ulaban halor ka jing don kam ki Pulit badang sya hikai ban bot Katkum ka kot kendon jonggaan hakapor toket ne kapor kem ya unu uriu bamman. Kajing bam tebat kajing bam la ban bot yaki kendon dagi Pulit hakapor ba penlong ka jing toket bon sien ka penduko yaki kies ka balam hadu ba yaki badok kisak kem kat ba ki beruspa kilat no. Ula ongru habayunu jor bat ki wei kiri ka Tnat Pulit jongkari India kadang bon kijing duna bat Katkum ka Kaiphod ka bala lom shispa stem menshwa lalap pa ka Tnat Pulit bat ka Tnat Bishar kadai ka wei na ki wei pat ki baklan hakajing Bamsap. U Justice Sanjeev Banerjee ula penparu ka jingdon kamban penyaper hapreng ka law and order but investigation lem kumta ka jingduna ha ka jingdon ki Pulit ka la ban penyaklet lang ya ka law and order but investigation but kani ka penlong ban ya pen ya ka jinglong jong ka jing toket. Ula kren sapang ka bor jong ka khmat halor ka bor jong ka jing tho bat ka ktien. Bat ha kani ula kado ya ka jingdon kam jong ka videography ha ka por ka jing toket lani ha ka por pla daunong pla. Ula kentu ya ki bor pet jong ka jela ban ai kum kita ki resource ba ka Tnat Pulit kan nang la susu ban pentbet ya ladi.
Indeed, for a judge in the Indian system, we are used to reports which are well below par. From my experience of more than 17 and a half years as a judge of the High Court, I can tell you that I am elated if we get an investigation report or a prosecution case made up by the investigating agency which is approximately 60% of the desired level. That is also a rarity. There are many other instruments, many other facilities which are now available, which are used on a daily basis in the more developed jurisdictions, particularly the use of technology. However, because of our limited resources and because of the even more limited resources made available to the police, we do not avail of many of the scientific facilities. Indeed, we do not have adequate number of forensic science laboratories. We do not have facilities to keep stuff in controlled temperatures. We are in a tropical country. We do not get things tested within the time beyond which it goes bad. Routinely at post-mortem examination, the contents of the stomach are extracted and sent for FSL examination, but that report never comes. Neither would even reports pertaining to undergarments of the accused and the survivor in crimes against women, even those reports sometimes don't come unless they are specifically chased. I begin by saying that these two institutions, the police and the judiciary in this country, require a tremendous image makeover. No one wants to be associated with courts. No one wants to come to a court unless absolutely pushed. Similarly, any normal person in this country cringes when the police or a policeman comes nearby because a policeman over here is understood to spell trouble. Which is why, in many cases, we don't have witnesses coming forward, no one willing to give statements, because they feel that if they do, if they associate themselves with the process, a lot of unnecessary time would be wasted, both with the police and ultimately in course of the trial in courts. There is a room for tremendous image makeover. However, that image makeover cannot take place till we have adequate resources. The Amnesty International surveyed several institutions in this country about a decade back, and its opinion was that the police is the most corrupt organization in this country, followed by the judiciary. I don't know whether it surveyed politicians or not, but there was no institution as politicians which could be surveyed possibly. But when it claimed that the judiciary was second corrupt to the police, what it meant was not only judges, but the entire lot, meaning judges, lawyers, clerks, office staff, all together. In India, the judge population ratio is terrible, and second in the scale of worst to the best to only the police. The number of police personnel necessary is woefully inadequate. Further, like in the judiciary, where we select people from the bar who come through a faulty education system, even in the police, there is not effective training in respect of the work which is required to be done. Like junior lawyers, policemen also pick up while on the job, and you learn by seeing others instead of there being some kind of a system. Yes, you go through some kind of a training school for some time, but that is more like, being imparted some theoretical education and some bodybuilding exercises. The actual training which is necessary is not imparted neither to lawyers at the junior level, who pick up by seeing how things are going on in court, how their seniors are functioning, or police officers who also follow a similar line of course of action. Having said that, given the resources, there is room for improvement for both for the judiciary and for the police. So I begin with that caveat. And at the same time, I want to remind all of you present here, that we are about 17 years on from the year 2006, when the Supreme Court, in a landmark judgment known Prakash Singh, exercised its authority under Article 32 of the Constitution, read with Article 142, to indicate that serious police reforms have to be undertaken. And the time limit given both to the central and the state governments was 1 year. It was less than a year. The judgment indicated that by the turn of the next year, these things should have been done. And what were the recommendations? And I'll read you just the salient features of the recommendations. The first was that every state would have a state security commission. What would be the composition of the security commission? The Supreme Court sought suggestions from 3 different entities. First was, it asked the National Human Rights Commission to make a suggestion as to what should be the composition of the state security commission. It also sought the opinion of a very senior and respected police officer, Julio Ribeiro, the person credited with quelling the uprising, so to say, that happened in Punjab. And it also requested a legal luminary, Soli Sorabji, to file a report. According to the National Human Rights Commission, every state security commission should have the Chief Minister as its chairman, Lokayukta, a sitting or retired judge nominated by the Chief Justice, the Chief Secretary, the leader of the opposition in the State Assembly, and the DGP as its ex officio secretary. According to the Ribeiro Committee, it wanted the Minister in charge of police as the chairman of the State Security Commission, the leader of the opposition, a judge sitting or retired to be nominated by the Chief Justice, the Chief Secretary, 3 non-political citizens of proven merit and integrity with the DGP as secretary. According to the Sorabji Committee, the chairperson of such commission would be the Minister in charge of police, the other members would be the leader of the opposition, the Chief Secretary, the DGP would be the ex officio secretary, and there would be 5 independent members. As to how the independent members would be selected, there was also a procedure which was indicated by the 3 committees. You would know that there is already a provision in this state and in several other states where certain appointments need the concurrence of the Chief Justice or the nominee of the Chief Justice in such regard. That is because when you have a majority party in power, if all of the adjudicatory authority or regulatory authority is conferred on bodies which are chosen by the majority, then it would not be reflective of the general, but it would be a kind of a majoritarianism which would be followed. And therefore, the need to have the leader of the opposition, nominee of the Chief Justice, and independent persons, so that the government of the day did not have overwhelming control over the Security Commission.
Congress, Kino. We have a check up and
I not say Atiar.
yeah,
Hila banet la shem tayoru. Sele yu dengan Islam kendian.
Islam kendian. Ti takadaw kolong kapakong san ban pat ya kapor.
Kalau ke badan kamban letas ya ke kemishwa bandap lai benai ba armet kenang ba ikelung enom yo yu kenyang HIV hakaba ikmi bat ikelung kenyo kecing em kabakai kabakia bat Islam.
Dor jong kapor.
HIV control.
Patas HIV yalla de hakabor ba pilit check up ning bang haba armet.